10:14 a.m., October 9th, 2025, Savannah, Georgia. A branch librarian named Carol Dreher was working through the last of a donated estate collection, 43 boxes, most of it legal textbooks and outdated tax manuals. She had been at it since 7 in the morning. The work was routine. The box she reached at 10:14 was labelled miscellaneous, law reference. Inside, a stack of paperback supplements, a broken 3-hole punch, and a 2004 edition of Federal Securities Law and Practice. The book was heavy for its size. Dreher fanned the pages. A sealed business envelope fell onto the sorting table. No address, no stamp. One handwritten line on the front, in blue ballpoint, "Do not open until I'm gone." The donor had died 6 weeks earlier. His name on file was Paul Greer. He was 61 years old. He had lived in Savannah for 19 years. He died of a cardiac event on September 1st, 2025, alone in his home on the west side of the city. Dreher set the envelope aside. She kept sorting. But she came back to it twice before lunch. The second time she picked it up, she held it for almost a full minute. The envelope was sealed with standard adhesive, not tape, and the flap had been pressed down with care. No wrinkles, no gaps. Whatever was inside had been placed there deliberately by someone who had thought about the act of placing it. That was the feeling she would describe later. Not alarm. Something quieter. The sense that an object had been waiting for a specific moment that it had now reached. By the end of the day, she had placed it in a sealed evidence bag from the library's disaster preparedness kit and called the non-emergency line at the Savannah Police Department. She told the dispatcher what she had found. She told them she did not know if it was anything. She just felt that someone else should decide. Within 48 hours, the envelope was in the hands of the United States Marshals Service. What it contained was not a will. It was not a financial record. It was not anything the receiving detective had expected. Inside, a handwritten note, 3 pages, on yellow legal pad paper. A photocopy of a federal grand jury subpoena, dated November 14th, 2003, issued in the Western District of North Carolina. And one additional item. A square post-it note, pale green, stuck to the inside flap with dried adhesive. It read, in the same blue ballpoint, "I didn't mean to hurt anyone. That's not an excuse. It's the only true thing I have left to say." The name on the subpoena was Marcus Feld. The U.S. Marshals Service ran the name through NCIC within the hour. Marcus David Feld, born September 23, 1963. Charlotte, North Carolina. Securities broker, licensed by FINRA from 1994 until the revocation of his license in 2004. Subject of a federal wire fraud investigation beginning in late 2002. Indicted by a federal grand jury on 11 counts in February 2004. Trial date set, April 14th, 2004. He had never appeared for trial. He had been declared a federal fugitive on April 17th, 2004. His warrant had been active ever since. 21 years, 4 months, and 23 days as of the morning Carol Dreher made her phone call. The man who had died in Savannah on September 1st, 2025, calling himself Paul Greer, was Marcus Feld. Estimated losses from Feld's securities fraud scheme, $38 million. Estimated number of victims, 140 retail investors, most of them working-class families in the Charlotte metropolitan area. The money had been gone for over 2 decades. What no one outside a small group of federal case managers knew, and what the sealed envelope was about to reopen, was that some of it might not be gone at all. The original case against Marcus Feld had been built over approximately 18 months by the FBI's Charlotte field office, working with the Securities and Exchange Commission and the U.S. Attorney's Office for the Western District of North Carolina. It was not a complicated scheme, as federal fraud cases go. Investigators called it a classic affinity fraud with a structured distribution overlay. Feld had operated under the name Carrington Wealth Management, a registered investment advisory firm he incorporated in Charlotte in 1997. The firm was real. It had a physical address on South Tryon Street. It had letterhead, a website, sparse by later standards but functional for the era, and a client intake process that mirrored what a legitimate broker would offer. Between 1999 and early 2003, Feld solicited investments from 140 individual clients. His pitch was consistent. A proprietary bond rotation strategy, low risk, producing annualized returns of between 11 and 14%. He produced statements every quarter. He held annual review meetings. He sent holiday cards. The statements were fabricated. The money was not being invested. It was moving through a sequence of intermediary accounts. 3 in the Cayman Islands, 1 in Panama, 1 in Delaware, 1 in North Carolina. And being drawn down in withdrawals that, on any individual statement appeared to be management fees, transaction costs, or liquidity transfers. The structure was not elegant, but it held. Between 1999 and 2003, no single transaction triggered an automatic report. I spent time going through the original indictment documents, and one detail kept coming back to me. The SEC examiner who first flagged the Carrington accounts did so not because of the fraud itself, but because of a paperwork discrepancy involving a single client's wire instruction form. One form, misfiled in a routine examination sweep. That was the thread that pulled. By late 2002, the FBI had opened a parallel criminal inquiry. By mid-2003, they had enough for a grand jury. By February 2004, the indictment was sealed and then publicly filed. 2 days before trial, on April 12, 2004, Marcus Feld did not appear at a routine pretrial conference. His attorney, who claimed to have had no prior knowledge, reported the no-show. A bench warrant was issued that afternoon. A federal fugitive warrant followed. He had taken approximately $6.2 million with him. The rest of the $38 million, roughly $31.8 million, was never fully accounted for. Investigators believed most of it had been spent or dispersed across accounts they could never fully trace. Some may have moved abroad. Some may have been converted to untraceable instruments. The case file remained open in the Fugitive Division of the Charlotte FBI office, but after several years of diminishing leads, active investigation had largely stalled. Before the investigation stalled entirely, agents in the Charlotte field office made a serious push to locate Feld through the network of people who had known him. They interviewed former colleagues at 3 brokerage firms where he had worked before launching Carrington. They interviewed his ex-wife, who had divorced him in 2001, and who was, by every account investigators could develop, entirely uninvolved in the fraud. They interviewed neighbours from the Dilworth neighbourhood house he had vacated in early April 2004, 2 weeks before his scheduled trial date. They pulled his passport records. He had travelled to the Cayman Islands twice in 2002 and once in 2003, ostensibly for client meetings, and issued international lookout notices. Interpol was notified. None of it produced a confirmed sighting. After 18 months of active pursuit, the leads had narrowed to nothing. Feld had simply stopped being visible. What Marcus Feld did next, and how he managed to stay invisible for 19 years in a mid-sized American city, is a story about the mechanics of identity fraud and about the limits of federal search capability in the years before biometric integration. He had not built an elaborate cover. That was the detail that struck investigators almost immediately when they began unravelling it. Paul Greer was not a masterwork of fabrication. He was a minimal viable identity, the least complex version of a new life that could still function. The social security number Feld had acquired under the Greer identity had belonged to a man named Paul Anthony Greer, born in 1961 in rural Georgia, who had died in 1974 at age 13. The practice of using deceased children's social security numbers as the basis for false identities, sometimes called the tombstone method in law enforcement, had been well documented since the 1980s. But in the years before the Social Security Administration implemented electronic death record integration with credit bureau systems, the lag time between a death and the deactivation of a number could stretch for years or never close at all. Feld had obtained Greer's number through means that investigators in 2025 were not able to fully reconstruct. The most probable assessment, through a document broker operating in the southeastern United States who had been prosecuted on unrelated identity fraud charges in 2008. The connection was circumstantial but consistent with the investigative timeline. With the number, Feld had obtained a Georgia driver's license in 2004, then a Georgia state business license, then a federal tax identification number for a small firm he incorporated under the name Greer Financial Services in 2005. The tax consulting firm became the anchor of his new life. It was small, deliberately, sustainably small. He never had more than 40 clients. He never applied for any federal certifications or licensing that would trigger background checks. He filed his taxes as Paul Greer. He paid his taxes as Paul Greer. He lived in a modest house he purchased in 2007 for $112,000. He paid off the mortgage in 2016. He coached Little League for 11 years. He served as treasurer of the Savannah West Chamber of Commerce from 2014 to 2021. He received commendations from the mayor's office in 2017 and again in 2022, both for civic contributions. He had no criminal record under the Greer identity. Not a parking ticket. What's most striking about this case isn't that Marcus Feld evaded capture for 19 years. It's that he did so almost entirely through behavioural discipline rather than technical sophistication. He didn't move abroad. He didn't cycle through multiple identities. He He didn't use cryptocurrency or offshore banking. He picked one name, one city, one profession, and he never deviated. The U.S. Marshals' Fugitive Task Force that inherited the reopened case in October 2025 faced an immediate procedural question. What exactly were they investigating? The fugitive was dead. There was no arrest to be made, but the warrant didn't close automatically with Feld's death. Federal fugitive warrants close through official judicial process, a motion, a ruling, an order. And while the warrant was still technically active, it gave federal investigators legal standing to do something that had not been possible before. To formally examine everything Marcus Feld had built under the Greer identity, including his assets, his accounts, and the estate he had left behind. The 3-page handwritten note found in the sealed envelope was not a formal confession in any legal sense. It had not been signed under oath. It had not been witnessed. It was addressed to no one and dated only sometime in 2024 in what appeared to be Feld's own handwriting. Confirmed later by forensic document examiners comparing it to authenticated samples of Marcus Feld's signature from his 1994 FINRA licensing application. The note described what Feld called a decision I made at 39 that I spent the rest of my life paying for in silence. It referenced the Carrington clients without naming them. It said, in one passage that investigators would later cite in federal court filings, I know what was taken from them. I know what that money meant to the people who trusted me with it. I have thought about that every day for 20 years. It did not specify account numbers. It did not identify where money was held. It was not a roadmap to the assets. But it was something else, a legal acknowledgement of identity, written in Feld's own hand, that the man named Paul Greer and the man named Marcus Feld were the same person. That single factual admission, even in an informal, unsigned document, was enough to anchor the federal legal theory that the estate of Paul Greer was, in fact, the estate of a federal fugitive, and therefore subject to the forfeiture provisions of the original 2004 indictment. There's a line in the federal court filing from November 2025 that reads almost like fiction. The government argued that Feld's death did not extinguish the indictment's asset forfeiture orders. It merely delayed their execution. That the estate had been, in legal terms, waiting. Deputy U.S. Marshals and FBI financial crimes analysts began parallel work in the second week of October 2025. The Marshals handled the fugitive warrant documentation and the formal notification to the estate administrator, a local Savannah attorney who had been named in Greer's will and who, according to all subsequent investigation, had no knowledge of his client's actual identity. The FBI's financial crimes unit pulled credit records, real property filings, and tax returns for Paul Greer going back to 2004. The financial crimes analysts assigned to the Greer Estate Review were working against a 20-year paper trail spread across 4 financial institutions and 2 decades of modest tax filings. The lead analyst, a 12-year veteran of the FBI's Economic Crimes Unit based in Atlanta, later described the review in internal documentation as methodical rather than difficult. Feld had not tried to hide the money in any technically sophisticated way. He had spread it thinly and let time do the work. Municipal bonds purchased in 2009 had matured and been reinvested. Certificates of deposit had rolled over automatically. Index fund positions had compounded for 15 years inside individually unremarkable brokerage accounts. None of the accounts, taken alone, would have attracted scrutiny. The total, assembled across institutions, told a different story. What they found was a financial profile that was orderly, modest, and, once you knew where to look, clearly structured around avoiding visibility. Greer Financial Services had never invoiced more than $82,000 in a single year. The firm operated from a home office. Expenses were minimal. But the cumulative revenue over 20 years, combined with careful investment in low-yield instruments, municipal bonds, certificates of deposit, index funds held in small individual accounts across 4 different financial institutions, had produced a net estate value that surprised investigators. Total traceable assets held under the Greer identity at time of death, $6.2 million. Rounded to the same figure that investigators had estimated Feld had taken with him when he fled in 2004. Whether that was coincidence, guilt-driven accounting, or something more deliberate, no one could say with certainty. The money had not been sitting in a single account. It had been distributed, reinvested, and compounded over 2 decades. But the sum was there. Here's the take that might generate some disagreement. The fact that Feld apparently preserved the full amount of what he took, rebuilding it dollar by dollar through 2 decades of legitimate tax consulting, doesn't mitigate what he did. But it is operationally significant. He did not spend it on himself in any extravagant way. He did not move it out of the country. He rebuilt it and, apparently, intended in some form for it to be found. The sealed envelope was not an accident. You do not put a document in a specific book in a specific box in a donated estate collection by accident. The estate was formally frozen by federal court order on October 31st, 2025. What do you think? Was what Feld left behind a form of delayed reckoning? Or is it too little too late for victims who spent 20 years without answers? The estate administrator complied fully and immediately. There was no litigation over the freeze. The attorney later told investigators he had never had a client ask him to accept a sealed envelope as part of an estate administration, and he had simply not known what to do with the instruction. He had kept the books of the estate in order and waited. The U.S. Attorney's Office for the Western District of North Carolina, the same district that had originally indicted Marcus Feld in 2004, reopened the case file and filed a motion in November 2025 to confirm the fugitive's death, formally extinguish the arrest warrant, and transfer jurisdictional authority over the asset recovery to the Eastern District of Georgia, where the estate was probated. The motion was granted in December 2025. There were no doors breached, no tactical units in the streets of Savannah. There was a federal freeze order, a compliant estate administrator, and 2 decades of careful bookkeeping that had, in the end, made the government's work almost procedurally simple. But for the 140 investors who had been defrauded between 1999 and 2003, many of them now in their 60s, 70s, or older, some of them deceased, their claims potentially inheritable by surviving family members, the news came through a different channel. In January 2026, the Department of Justice Victim Notification System sent letters to the last known addresses of every individual identified in the original 2004 indictment as a victim of Marcus Feld's fraud. The letters explained that a subject of the original case had died in September 2025, that federal investigators had identified assets totaling $6.2 million traceable to the fraudulent proceeds, and that restitution proceedings had been initiated. $38 million had been taken. $6.2 million had been found. The gap, $31.8 million, remained unaccounted for. Some of it, investigators believed, had been spent in the years immediately after Feld fled, before he settled into the austerity of life as Paul Greer. Some may have moved through the offshore accounts identified in the original indictment and dispersed beyond practical recovery. The Cayman and Panama accounts had been closed long before any renewed investigation could reach them. Of the 140 original victims, 49 could not be located at the addresses on file. Some had moved, some had died. 9 victim families filed requests through the DOJ's Victim Assistance Program to be formally included in the restitution proceedings. The claims process opened in February 2026. Among the victims who were located, the responses varied in ways that investigators and victim advocates later described as spanning nearly the full range of human reaction to belated news. Some called immediately, wanting every procedural detail. Some did not respond for weeks. One man, a retired postal worker from Gastonia, North Carolina, who had invested $80,000 with Carrington in 2000, money his wife had inherited from her parents, reportedly drove to the Charlotte FBI field office in person after receiving the letter because he did not trust that the letter was real. He sat in the lobby for 40 minutes before an agent came out to confirm to him, face to face, that the case had reopened and that his claim would be included in the proceedings. He had spent 22 years assuming the money was gone and that no one in the federal government was still looking. A preliminary distribution plan was submitted to the federal court in the Eastern District of Georgia in March 2026. A posthumous federal judgment was entered against the estate of Marcus Feld, identified formally in the court record as also known as Paul Greer, on March 19, 2026. The judgment confirmed both the fraud liability and the forfeiture of the $6.2 million in estate assets. The distribution calculation, once administrative costs and legal fees were deducted, produced approximately $41,000 per identified victim, approximately 11 cents on the dollar, against original losses that had, for many investors, represented retirement savings they had never recovered. One investor, a former school teacher from Charlotte who had invested $114,000 with Carrington in 2001, was interviewed by a Savannah news outlet in April 2026. She was 72 years old. She said she had assumed for 20 years that the money was simply gone and that she would never hear about Marcus Feld again. She said receiving the DOJ letter in January had made her sit down in her kitchen and not move for a long time. She said she wasn't sure what to call what she felt. She did not use the word closure. Carol Dreher, the librarian who found the envelope, was not named in any of the court filings. Her role was noted in internal Marshals service documentation as the initiating civilian contact. She continued her work at the Savannah branch library. She was later asked, in a brief local press interview, whether she had any sense that something was off when she found the envelope. She said she had known from the moment she read the handwriting on the outside. Not because she recognized it. Because nobody writes, "Do not open until I'm gone" on a blank envelope unless they have been waiting, for a very long time, to say something. The Carrington wealth management case had been formally inactive for over a decade. Marcus Feld's fugitive warrant had been in the system for 21 years. The FBI file had not been closed. No federal fugitive file closes until there is a resolution, but it had not been actively worked since approximately 2012. There's something in this case that kept coming back during the research. The federal system maintained the warrant. It kept the file open. It didn't allocate active resources because the leads had dried up and the subject had seemingly vanished. But it never declared the case done. And that administrative persistence, that bureaucratic refusal to formally close a file without cause, is what made it possible for Carol Dreher's phone call to land somewhere meaningful instead of nowhere. The envelope sat in that book for an unknown period of time. Feld had purchased the 2004 legal reference sometime in the mid-2000s, according to what could be reconstructed from his home office inventory. It may have been there for 15 years. It may have been placed there recently. The document examiner who analysed the paper and ink of the handwritten note placed the writing at somewhere between 5 and 12 years ago, based on ink oxidation patterns. Feld had been sitting with it for at least a decade. He had also, investigators noted, donated the estate to the library himself. The will, executed in 2022, specified that his personal library be donated in its entirety to the Savannah Public Library System. He had chosen the destination. Consider the position of the federal prosecutor who had to file a posthumous fraud judgment in March 2026, making the legal case against a man who had already died, whose sole confession was an unsigned handwritten note, whose victim pool was scattered across 20 years in multiple states. The technical challenge alone was considerable. The legal theory was sound but untested in several respects. The government had to establish, in filings that would survive appeal, that the Greer estate was legally identical to the Feld liability. A question of identity rather than evidence of crime, argued on the basis of a handwriting match and a sealed envelope found in a donated book. It held. The judgment was entered. The assets were transferred. The Carrington case, as it existed in 2004, cannot be fully resolved. The original wire fraud charges died with the defendant. There will be no prison sentence. There will be no allocution in open court. There will be no moment when Marcus Feld stands before the families he defrauded and accounts for himself in any public way. What exists instead is a federal court record that now formally states what he did, who he was, and what was recovered. A number, 6.2 million. That will be distributed to a partial list of the people who lost far more. And a warrant, 21 years old, that is now formally closed. The 31.8 million that was not recovered remains unaccounted for. Some of the 140 victims will receive restitution. Some will not be found. Some are gone. The claims process was set to run through the summer of 2026, with final distribution expected no earlier than the fall. Whether there are other accounts, other instruments, other assets held somewhere under a name no one has yet connected to Marcus Feld, investigators could not say with certainty. The forensic accounting review of the Greer estate was completed. The offshore accounts from the original indictment were exhausted. But the gap between what was taken and what was found is wide enough that the question is not entirely closed. Think about whether this story stays with you, and whether you think what was left in that envelope was an act of conscience or an act of calculated control. A man deciding, even in death, how his story would be told. We read every comment. The file on Marcus Feld is closed. The estate is frozen and in the process of distribution. The victims have been notified. The money that's still missing, almost $32 million, 22 years gone, has no warrant attached to it anymore. That question stays open. If you want to follow what happens with the distribution proceedings and the remaining victim claims, subscribe. We'll update this case when the final numbers come in.